And this is DB versus B.J.B, and that is SAFLI reference ZAFSHC and ZAFSHC 112, 18 April 2024. As I mentioned, all the way from Bloom on 18 April 2024, and this is under the pen of Mgudlwa A.J. Short and sweet judgment, paragraph pages 98 to 102 of your bundle, page 10 on your summaries. What happened here is the applicant sought Rule 43 for monthly maintenance of 25 grand, relocation costs of 83 grand, contribution towards legal costs of 35,000 rand, and a contribution and continuation of payments for communal property and insurance. Respondent essentially pleads poverty, citing own medical conditions and reduced income. What is interesting about DB versus B.J.B specifically, folks, is that there is a very clear assessment of means versus needs. And I quite like this judgment of Mgudlwa A.J. It was very concise, to the point. What I've also done, you guys will notice on my summaries, for those of you who have purchased the summaries, I've started putting in on the Rule 43 cases what was asked and what was granted, because it's quite interesting to see the trends between the courts. So in this case, monthly maintenance of 25,000 rand was sought, 10,000 rand was given, and the respondent was ordered to pay the FNB bond. Respondent was also ordered to reinstate the insurance on the applicant's car and iPad. No contribution to costs, no contribution to relocation costs. And what the court essentially found in this instance, in taking the assessment of needs versus means, is the court was made aware of an amount of 190,000 rand odd that was lying in a bank account of the applicant, as well as a property that she was renting out to get surplus income. And the court basically dismissed the, from my reading of the judgment, and please do differ with me if your reading of the judgment is not the same. The court essentially dismissed the contribution to costs and the relocation costs based on the fact that the applicant had these means. So what the court says, it's settled law that maintenance includes, amongst other things, the provision of accommodation, food, clothing, car, and medical expenses. The general approach that the applicant is entitled to reasonable maintenance pending finalization of divorce. However, the person claiming maintenance must establish a need to be supported. The applicant's entitlement to maintenance must be assessed having regard to the standard of living enjoyed by the party during their marriage. This should be a simple and straightforward calculation of needs and means. I really like the fact that the judge distilled it down to this. It should be a simple and straightforward calculation of needs and means. And what is the aim? The aim is to avoid substantial prejudice to either party pending divorce. It is not to provide a precise account of what is due or to or from either party according to the parties or the court's sense of morality, propriety, the blameworthiness of the parties' conduct during the marriage, or their habits of living after the separation. The case should be cast in practical rather than moralistic terms, and the emotional heat of separation should be kept out of it. For those of you drafting Rule 43s who are dealing with overly emotional and combative opponents and really inflammatory papers, beautiful dicta here by Mgudlwa A.J. The case should be cast in practical rather than moralistic terms, and the emotional heat of a separation should be kept out of it. So DB versus B.J.B, really a short and sweet judgment. Very, very nice reasoning, I think, by the court. And I try not to give my own comment and rather try just to give the information. But in this instance, I really do like the dictas in this short paragraph, hitting the nail on the head with approach to Rule 43. What is the purpose? What do you look at? And how should the claims be formulated? Lovely judgment all the way from Bloemfontein under the pen of Mgudlwa A.J.